Well, welcome all of you to our panel discussion on professionalism, failures, consequences and answers. This is the third professionalism session we've had today. The first one was tended to be about present. The last one we had before lunch tended to be about the future. This one, in a sense, is looking at the past, but from the way I've been thinking about it is it's a bit like the actuarial control cycle. We've really got to look at what happened and see that we do this thing properly next time or whatever. So welcome. A particular thanks to our platinum sponsors, RGA Milliman and Actuaries. Thank you, of course, for all the people that have contributed to the organisation of this magnificent conference. It's amazing how many people are involved. And a special thanks, in fact, today to Tom Karp for having coordinated and got us going. So I will introduce the panellists later, but we're first going to watch a spectacular failure, which clearly was not actuarial, so we can watch it in a very disinterested and objective fashion. So we have 10 minutes of video on the way engineers shouldn't design buildings. So if we can go on.
At 7 p.m. on the 17th of July, 1981, more than 1,000 people were gathered in the atrium of the Hyatt Regency Kansas City Hotel for a tea dance, when a structural failure occurred. Two skywalks which crossed the lobby collapsed, crashing down onto the revellers below. The incident would cause the greatest loss of life from a structural collapse in American history, only ever to be superseded 20 years later by the destruction of New York City's World Trade Center. The Hyatt Regency Kansas City Hotel was part of the Crown Center complex, a suite of buildings owned by Hallmark Cards, consisting of both retail and residential space. The hotel stood 45 stories tall, with more than 700 rooms available for guests, as well as a grand ballroom and exhibition space. It was a popular venue, and the tea dances held there each weekend had swiftly become a phenomenon, drawing in ever-increasing crowds. People came to drink, dance, meet their friends, and enjoy an evening out on the town. By all accounts, the hotel was doing well. Construction had been completed just a year before, in 1980, and already it was a familiar landmark to many residents of, and visitors to, Kansas City. Of particular note was the lobby, an elegant, high-ceilinged space fitted out in metal, glass and concrete. As well as soaring windows to admit plenty of daylight, it also boasted 3 walkways which spanned the length of the atrium at the 2nd, 3rd and 4th floors. These walkways were left open during the tea dances, and people often gathered on them to look down at the crowd below. They afforded an excellent view of the entire lobby, and of the live band providing the entertainment. Survivors of the disaster which unfolded on the 17th of July 1981 report that there was little warning before the collapse occurred. At 7:05 p.m, several loud popping sounds were heard. Just seconds later, the 4th floor walkway failed, collapsing straight downwards onto the 2nd floor walkway, which failed in turn. The combined mass of both walkways crashed down onto the densely packed crowd occupying the ground floor of the lobby. Many victims who were caught in the collapse were killed instantly, but some did survive. They were left trapped in the mangled wreckage of the 2 walkways, pinned in place by concrete, glass and steel, gravely injured and inaccessible to rescuers. Worse still, the hotel's sprinkler system ruptured, flooding the ruined lobby with hundreds of gallons of water. Having survived the collapse, several victims were now at risk of drowning. A rescue operation began, but was almost immediately stymied. Many of the pieces of concrete were too heavy or bulky to be moved by the equipment the fire and rescue service had on hand. Fire chiefs appealed to the construction community who, without hesitation, provided cranes, drills and other heavy lifting equipment to help rescuers reach those people still trapped in the rubble. Digging down to reach survivors was not a pleasant task. Water was everywhere. The power had failed and there was little light to see by, with visibility further hampered by dust and debris. Furthermore, so densely packed was the rubble that in some cases the only way to reach survivors was by dismembering the dead bodies which blocked access to them. In a few cases, the only way to rescue someone was to perform an on-site amputation. In total, 114 people were killed and 216 were injured in the incident. Casualties were sent to nearly every available hospital in the area, while the dead were moved to a makeshift morgue in the hotel's exhibition area. The high number of casualties meant that almost everyone in the local area knew at least one victim. The psychic impact of the collapse was huge. An investigation was launched to find the cause, and its focus quickly narrowed to the construction of the walkways. Analysis of the wreckage showed that a change had been made from the original plans. The walkways for floors 2 and 4 were directly above one another. In the original plans, they depended from the same long hanger rods. But, in actual fact, these long rods had been switched out in each case with 2 shorter rods. This seemingly innocuous switch had been made based on a proposal from the manufacturer of the steel rods. Long rods would have to be threaded along their full length, and would thus be easily damaged during installation. Replacing each long rod with 2 shorter rods would make things much easier to manage, they said, and so 2 rods were installed in each case. It was never taken into account that this would change the forces which acted upon the walkways. In this new configuration, the beams of the 4th floor walkway, where the hanger rods were attached, now had to bear twice the load they had originally been intended to hold. This, combined with the number of guests crowded on the walkway during the tea dance on the 17th of July 1981, was what had precipitated the collapse. Analysis of the wreckage revealed that the nuts holding the walkway in place had pulled all the way through the box beams against which they had been secured. While this was the main factor in the collapse, it wasn't the only issue highlighted by the investigation. Numerous other safety violations and breaches of protocol were discovered. During the hotel's rapid construction, preliminary sketches had been used as though they were final signed-off drawings, and changes to the design had sometimes been confirmed by a quick phone call, rather than by the submission of revised plans. The issue which caused the collapse of the walkways at the Hyatt Regency Kansas City Hotel was, according to the original designer, so obvious that a first-year engineering student could have spotted it. But it had gone unnoticed, with the various companies and contractors involved in the construction of the hotel all assuming that someone else had done the work of verifying designs and running calculations. The disaster, and the hundreds of deaths which resulted from it, had been caused, in short, by poor communication and a laissez-faire attitude during a rushed construction project. The engineering firm, Jack D. Gillum and Associates, had been responsible for the original design, and had approved the final drawings. In the aftermath of the disaster, they were stripped of their license to operate in 3 states, as well as their membership of the American Society of Civil Engineers. No criminal charges were pursued against the firm, but owner Jack D. Gillum, who had been an engineer of note on the project, was haunted by the disaster for the rest of his life. He spent his remaining years lecturing and speaking about his involvement, in the hope that the story would scare young engineers out of making the same mistakes that he and his company did. More than 300 civil suits were brought against those involved in the construction and management of the hotel. These lawsuits yielded billions of dollars in compensation, a large portion of which was set aside for charitable causes to help the Kansas City community heal and move forward in the wake of the disaster. Even when agreeing to pay out compensation, everyone connected with the case denied all legal responsibility. Numerous changes were made in the fields of civil engineering and construction in the wake of the disaster. The collapse was international news. In countries around the world, the curriculum for engineering students was completely overhauled, with a new emphasis on responsibility and safety. Standards were raised and trade manuals revised. The walkway collapse remains, to this day, a sobering case study for budding engineers, one which underlines very clearly the importance of good communication and adherence to protocol. A memorial, dedicated in 2015, now stands in Hospital Hill Park, close to the hotel, which itself has been entirely restored and refurbished. The 2 collapsed walkways which once crossed the lobby have now been replaced by just one walkway, supported by pillars rather than hanger rods. And the hotel has been renamed. It is now known as the Sheraton Kansas City at Crown Center. Thanks to the sweeping changes which took place in the wake of the disaster, it has been described as one of the safest buildings in the country. The legacy of the Hyatt Regency walkway collapse is one of pain and trauma, but it is also a legacy of learning. Just as the renewed and reconstructed hotel is safer than the old Hyatt Regency, so too are other buildings the world over. The lessons learned on the 17th of July 1981 were excruciatingly painful, but they were lessons, at least, that stuck.
Very sobering. So we'll move now to 2 presentations from 2 of our panel, and then once they're done, we will have questions and answers, with all 5 members of our panel there. So if you want to start making comments, asking questions, please go on to the app, refresh it. Click the button now on at the bottom and ask your question, and we'll deal with them at the end of the presentation. So the first 2 presentations, the first one is going to be given by David Minty, who's a principal at Affinity Consulting, and he will be talking about his experience with the James Hardy in the long distance past now, David. I've known David for some time, and I've been very grateful for the way in which he's presented versions of this talk at various student meetings, as a visiting lecturer many times. So I have heard it before, and it's great. Dean Sanders will then follow him, He's the lead partner at Deloitte on integrity. He's an adjunct professor of the University of Newcastle. And he'll be talking about his work that partly comes from leading the professional body dealing with financial advisors, but is much broader than that in different ways. So we'll have those two presentations, and then the panel will come up and we'll start our discussion. So thanks, David.
Thank you very much, Mr. Chairman. Now we're going to turn to something which is a little closer to home for our profession, the actuarial valuation of financial liabilities. I'm grateful to the session organisers to be able to share insights from a high-profile Australian case in which I am personally involved. I plan to outline the timeline. I think it's helpful to know, to have that as by way of background, to give you some context. Reflect on what I believe brought about my failure, consider steps we could have taken that might have helped or reduced the damage, and finally the consequences for me and for others. It was interesting as I watched again that video just then that Jack Gillam spent the rest of his life going and talking to students of engineering about what had happened, and I feel in some ways that's what I've been doing the last few years as well. I hope it has been constructive. Hopefully this is going to contribute to our profession, helping members to deliver the best possible advice to our clients and to society more generally as we navigate increasingly complex situations involving many different parties. So, James Hardie. Some of you, I expect, will know that name. You will definitely know it if you're Australian, but also, of course, the US, because it was and is a significant Australian manufacturer of building products. It was Australia's biggest user of asbestos. From 1987, when the first successful litigation for an asbestos-related injury occurred, the volume and cost of claims started to increase. Note that James Hardie was not a financial services company. Now, for 4 years, from 1996 through to year 2000, when my colleagues and I, then at Trowbridge Consulting, provided 3 reports to them, James Hardie management was focused on US expansion and dealing with what for them was a legacy issue. These claims from former employees and users of the products who'd contracted asbestos-related diseases. We were told our work was being used only for internal monitoring and claims management purposes, not for financial accounting. In early 2001, as Trowbridge Deloitte, a colleague and I presented to a group we were told included members of a new management team for the Australian business. Shortly thereafter, James Hardie issued a statement that its asbestos-related liabilities were being separated from the group and would be overseen by a new medical research and compensation foundation, which would also fund research into potential treatments for asbestos-related diseases. The liabilities were described as fully funded in the press release. The publication of the press release was the first time we'd heard about a separate fund. I discussed with colleagues if we should speak or write to James Hardie, but decided that the CFO and other managers with whom we'd been advising were well aware of the limitations of our advice and that raising this with them in writing would not alter their actions. The foundation was created, and from my colleagues and I were engaged by the directors from 2001 to 2003 to value the liabilities. In June 2003, we prepared a background paper discussing broader issues of asbestos-related compensation, as well as the Foundation's financial position. This was for the Foundation directors to discuss with both Australian federal and state governments, because those governments also had significant asbestos-related liabilities themselves. Following those discussions, the New South Wales Government called a special commission of inquiry into James Hardie's actions in February 2004, before which I appeared for several days. It reported its findings in September 2004. For me, nearly 2 years of investigation by the Actuaries Institute followed. Sorry, wrong slide. And I was reprimanded with publication of a notice to that effect in newspapers nationwide at the beginning of 2007. That's on the slide now. The Professional Conduct Tribunal determined that I'd allowed my advice and its limitations to be presented in a misleading way to the incoming directors of the Foundation, and that I had thereby failed to fulfil my obligation to the public interest to provide high-quality actuarial advice and service. Following completion of the Special Commission of Inquiry, and while the Institute investigation was happening, the corporate regulator, ASIC, became involved. Through 2007 and 2008, I prepared affidavits that helped develop cases against James Hardie directors and management. I had no further involvement in the litigation, although it took a further 4 years for the last appeal to be determined and civil penalties to be imposed on James Hardie and its directors and managers. So what caused my failure? Well, with the benefit now of over 20 years, including preparation for multiple inquiries to reflect on this, there are a number of areas that I and others failed to consider. First, we were too close to the detail and we weren't thinking about the bigger picture. We failed to take sufficient time to reflect on how our advice was being used and the potential ramifications, particularly for people who had not commissioned it but were likely to be affected by it, both the new management team and potential claimants. Second, there was pressure from our then client to quickly provide additional information and update the draft presentation. Everything was very, very urgent. And with the workload in a busy consultancy, with lots of active projects for many clients, I believe that contributed to the third point, failing to take time to recognise the change in the nature of our engagement, from one which was internally focused to something where a new entity was being set up, this foundation. Of course, part of that was, in hindsight, a result of the way our involvement was being managed by the existing James Hardie management, which brings me to point number 4. We were accepting the data and statements of management at face value, and we were never fully in the room when they were doing much of their planning. As evidence presented by a number of James Hardie managers to the Special Commission of Inquiry showed, I was deliberately kept in the dark and only rolled out when needed. So putting the interests of the direct client, the existing management team, too much ahead of the incoming management team and the public interest was the cumulative outcome of those failures. The extent of what was going on only became apparent once the press release was published, but after that unexpected revelation, we should have been proactive to bring the potential issues to what we could now see to the attention of both existing management and the new team, even though the new management were not yet our client. We felt wrongly that confidentiality clauses prevented us doing this because, of course, at that stage the new management were not on board. So what could have helped? Firstly, we should have recognised the change in the nature of the advice we were being asked to provide, although in some respects that only emerged as we presented to the new management team and immediately afterwards. Now, we could have put in place a new engagement letter for the work, because we were really just running under the previous engagement letter that we had. If we'd prepared such a letter, we'd have probably established a more extensive review and sign-off procedure, including potentially involving people less closely involved in the preparation of the advice. And requiring James Hardie management to sign a new engagement letter may have also changed their approach, who knows. Thirdly, the engagement issue was compounded by Trowbridge's merger with Deloitte in June 2000. Lots of internal changes and new systems were being implemented, but certainly weren't completed at that stage. And I expect if that merger had been completed 2 years earlier, more robust systems would have been in place, as they now are at both Deloitte and Finity. So I believe lessons have been learned internally by us, and as I'll go on to say, by the Institute. So were there consequences? Yes, ultimately the 9 Australian members of the Board of Directors of James Hardie were sanctioned by the New South Wales Supreme Court for false and misleading conduct, with fines and 3-year bans from managing companies. This ended the careers of several prominent non-executive directors. Some senior James Hardie managers and US directors were also sanctioned, but possibly with less impact on their careers. The provision of ongoing compensation to claimants was secured by a funding agreement that James Hardie entered into in 2006 with the New South Wales Government to direct a proportion of their future profits to meeting those costs as they emerge. Fortunately, the commercial success of James Hardie, particularly in the US, has enabled the now renamed Asbestos Injuries Compensation Fund to continue to meet those liabilities, which remain estimated at around $1 billion today, even after the claims that have been settled over the last 20 years. The Special Commission of Inquiry, the Actuaries Institute disciplinary process and assistance to ASIC cost Deloitte multi-million dollars in legal costs and me and others hundreds of hours of time. I ceased to work for some clients because of the association with James Hardie. In fact, I chose not to become a partner when Finity demerged from Deloitte in 2005. I am actually a senior consultant still with the firm. I do hope that relating these circumstances to student actuaries at the University of New South Wales for a number of years has had an impact on the profession. Certainly over my career subsequently, this hasn't been something which has given me something on the speaking circuit as a career, but there you go. And of course, the impact on the Institute has also been reasonably profound in the sense that we've gone through a number of changes of the Code of Conduct, and you might notice that I have been involved in both the last drafting committee for the code, which is now a principles-based code, as well as other activities in the Institute. So I hope that's some recompense to people for the time and effort that's gone into this. Throughout this saga, I am grateful to so many people, to Deloitte, to the many lawyers I worked with who were retained by Deloitte, and to my colleagues at what became Finity Consulting for all their support through the various inquiry processes and beyond. For clients who retained us despite the very public link with this controversy. For my wife Judith, my church and so many friends who are, and for their unwavering prayers and love. And to my unchanging and faithful Saviour, Jesus Christ, knowing that beyond the challenges of this life is a purpose and eternal future for each of us, and that comes only because of Christ's death in reconciling God to everyone who reaches out to him in faith, regardless of what we've done. So, in conclusion, could matters like this emerge again in future for actuaries, particularly those operating in areas beyond traditional financial services? Well, I hope that the exposure of cases like this, as well as developments in the code, will ensure that that is less likely, but it does rely on the continued vigilance of each one of us and considering the circumstances in which we find ourselves from day to day. Just doing a course once is not going to give us the insights that we need. We need to be constantly reflecting on these things. Those who don't learn from history or who forget history are unfortunately destined to repeat history. So I'm encouraged that in the unlikely area of the coal industry, a young Christian actuary has in fact called out the falsification of quantity certificates in 2019, just 5 weeks into a new job. Can you imagine being in that situation? His and his wife's bravery in taking that stand through unfair dismissal proceedings to the point where ASIC, the company's regulator, is now pursuing 4 directors and senior officers of a large coal miner for conduct harming a whistleblower, gives me hope that individual actuaries can make a difference in such situations, provided we're prepared to stand up. I ought to have been as courageous in the James Hardie case as Justin is. The fact this case is current indicates that constant vigilance by each member in whatever situation we find ourselves remains paramount in our role as actuaries. Thank you.
Thank you very much, David, for your courage and for those insights. Deen, over to you.
Thank you, Chair, and thank you. I'm going to walk around behind David, as is the culturally appropriate thing in my space, not to walk in front of people in between the fire. My name is Deen Sanders. I actually feel as though I'm perhaps now meant to be entering in some sort of response from Deloitte, which is not the point of anything to do with my role here. I want to bring you in a different purpose. I'm here, frankly, I don't think, and I'll have to ask Tom this, whether Deloitte had anything to do with the reference there has to do with it, because my background, in fact, is not as an actuary. I want to respond to that particular challenge. My background is in regulatory law. I spent most of my life in the professions and regulatory spaces around all professions, all non-medical professions in the space of regulating accountants and lawyers and others, etc. So my professional life is in the world of regulatory law. But the conversation I want to sort of bring to this one is that my academic life, my professional interests are in the world of complexity, in the relationships between these things. And I think this is perhaps a conversation. I don't want to be challenging necessarily the David story because it's quite important truth to tell. but I want to put that story in the context of the whole spectrum of professional responsibility. I don't want to let anybody off the hook, but also want to put everybody on the hook, which is the nature of the particular challenge. I also begin that sort of conversation as an Indigenous person. I'm a Ngarinyang Wanangaguri Waramai Gippa. I'm a Waramai man from Mid-North Coast, New South Wales, up that way. A couple of hours up the road for those of you who know Mid-North Coast, Port Stephens, Taree country. I grew up in freshwater country, and saltwater country is my nation group. I want to acknowledge that this country we're on, because I think that's an anchoring point for these types of conversations too, that we are on Gadigal country, as you know. So Ngarinyang Gadigal Baragaba, in my language, Gadigal country. I want to anchor that for you because I have to admit I haven't been in this building for a couple of months, and I was a bit shocked as I was just walking around out there because there's a fair bit of building going on. A fair bit of destruction going on. I appreciate it's creative destruction with the intention that something else will live there, but I don't know if you know that this country in particular, this place we are standing on, this landscape that's literally out there, this was sacred country here. This is in fact a burial ground we are standing on. So I was quite surprised to see just outside there. I encourage you as you walk out there to see that country and recognise this was all sand. The water, the life of the Gadigal people of this country, this was just streams. They watched this harbour be born that's out there, and it was all just sand dunes, and sand country was where the people of this country buried people. So I want to anchor that in the concept of, I want to anchor that conversation for you in the concept of time, recognising that this time has an important role to play, and David spoke about the number of years with the James Hardie case, but also even the Hyatt case. And this idea of how we as human beings have been focusing on our ecosystem of relationships across professions. In fact, I would argue that we've spent a lot of our time in the last 50 or 60 years pretty much buggering things up by drawing lines between things, false lines. Yeah, by sectoralising, by specialising, by creating bifurcations in our responsibilities. You know, shifting responsibilities on this line or over that line to sort of say it's somebody else's problem, it's not my problem. That whole concept has, in fact, I think, created many of the challenges we face today. It doesn't exist in the systems, in the traditional systems of knowledge systems like mine, which are systems-based thinking. Everything is connected. So let's talk about that for a second. This idea of the not our problem, which I think goes to the heart of this. Now, I appreciate there's a distinction, an important distinction between the legal response from the engineer who was talking about not wanting to admit legal liability. There's an important reason for that. but the idea, nonetheless, of accepting personal responsibility. And I hear that in David too and acknowledge that. I acknowledge the idea of personal responsibility being a distinct difference from legal liability. But in ethical worlds, and Deloitte Integrity, the practice I lead, is a business focused on integrity. And I use that word integrity very deliberately. Integrity in my world means wholeness, not just ethics. How do you make something whole, something that has integrity? So most of my life I spent thinking about the whole systems rather than the individual. So the idea of how do you resolve that problem of ethical distancing? And as you know, the ethical distancing idea is if we can just get sufficiently distant from it, it's no longer our problem. This, I think, is one of the challenges we face. For too long, we've established this sort of idea of issues sitting, in the case of financial services products, and we're going to talk about some of those things, I think, here, and ostensibly, one of the roles I've held, yes, was regulator of professions, but also, in particular, I didn't represent the financial advisors, I was the regulator of financial advisors, I want to make that pretty clear, and one setting up, in fact, the standards and regulatory systems around that particular community, and failed, by the way. The regulatory architecture in that space failed, which is an important part of this story. But in the financial services sector, as you all know, for those of you across all jurisdictions, all countries, we spend a lot of our time thinking about the regulation of the distribution of products. The people at the bottom end of that chain, the salespeople, if you like, regulating the conduct of that end of the system, trying to not necessarily see the responsibility that sits higher. But in our case, and that's this idea, it's built on the principles, if you like, of freedom of choice and unlimited access to products. It's an inherent principle. Everybody should be able to have access to everything, but they should be safe in doing it. Because a product can't hurt somebody, just the wrong product in the wrong hands could hurt somebody. That's the theory. That's our entire regulatory architecture, by the way, for financial services in this country, is that products aren't inherently wrong. It's the salespeople who are wrong, or they're the wrong product in the wrong hands. But as you probably can see, it doesn't take a little bit to sort of squint your eyes and see through that to the idea of, hang on, this sounds very familiar to us, as an argument of guns don't kill people, people kill people. I think we all understand the inherent flaw in the ethical logic of that. It may well be a choice logic, but it's an ethical failure. And I think this is one of the challenges I want to bring to this room, is that it's not, we can use excuses, we can position ourselves differently, but I'm going to challenge you a little bit to say, no, actuaries are on the hook. And I think you haven't, frankly, accepted all of that hookerness in relation to your, I'm just going to invent a word there, it's just in all relation to all of your obligations of the past. Let's talk about that a bit. We have, just for comfort for those of you in the financial services sector and elsewhere, we have in fact introduced, as you know, regulations recently in the context of that, design and distribution obligations that do overlay the construction of products. So we have attempted to repair that, but frankly, it's a band-aid on a much more significant problem. Let's talk about that chain, just briefly. You know, there is a point, I think we all accept, that where anything intersects with the consumer, there is responsibility. So there is clearly responsibility for people who are distributing financial products. That's why the regulatory system sits in its current way. So is this the right product for the client? Now, in the gun argument, I'm not going to use that analogy much longer. It's not relevant for my thinking, but it's worthwhile saying that that's essentially putting the gun shop owner, making them responsible for whether they can do a mental health check, a psychological profile of bankruptcy and credit history, a divorce analysis, a trauma analysis on the person who's buying a gun over the counter. It's much more sophisticated in financial services. That's the good news. That's the one thing. But it's worthwhile saying that that's at least where that product sits. So product choice is a decision, is an ethical moment. It's that idea of, does this product do what you promised it would do? That's the test, if you like. That's the moment of test. If you're offering a product to a client, does it do what it said it would do? That's where all of our regulatory pressure has gone so far in our marketplaces. But there's other players in their system. There's the distribution system itself. This idea of what is the professional way to distribute products. And this in the Australian market, and true in other sectors, I believe has let most of the licensing marketplace, licensees of financial products, manufacturers of financial products, completely off the hook. They're not really responsible. If you prefer banks and investment entities, if you like, just as an example of creators of product, they have different obligations, but very rarely do they have the obligation that says, what is the professional way to distribute this product? Because of course we're looking for what's the cheapest way, best way, most substantive way, maximum exposure way, all those things rather than what's the most professional way. I want to bring it back to actuaries. We have got, as I said before, DDO compliance in this country that sits there. Compliance, if you like, versus fairness is an important part of that conversation. And this brings the regulatory lawyer out in me because, of course, I spend most of my life arguing the difference between compliance and fairness. You know, this idea that somehow, well, it's perfectly appropriate to be compliant and wholly unfair, both at the same time. These sort of principles sit in contrast with each other. And I argue that they are all of ours in responsibility. And regulation is, in my view now, having written laws, regulated markets around professions, having been the author of what's been adopted accidentally, I think, as the world's professional framework of the 5 E's, regulation is a poor tool for professionalism, in my view. I've arrived at that conclusion with the grey hair and pain, that regulation is a poor tool for professions. Professional regulation is the right tool for professions, but I would challenge the Institute as to whether that's actually happening. That's a different story entirely. I think, in fact, there's more work to do. I say that, by the way, not as a regulator anymore, so that's nothing for anybody, any particular pressure. Now, I want to bring you into this circle. I want to bring the actuaries in because further down the chain, we've even got the question about, is it even the right thing to sell to people? You know, because I remember as a baby regulator many years ago when ASIC was first born, we used to hold in those days summer schools, which were an exercise in sharing information between us as marketplace and regulator to learn from the marketplace what's going on. I remember asking, on the stage at that time, we had this very sophisticated investment bank being interrogated by us as interested parties. How do you arrive at products? How do you invent products? And the bloke on the stage said, I don't know. I go down there and they ask them a question, go down there and ask them a question. That sounds cool, can we do that? And suddenly a product is born and the entire regulatory audience takes a deep breath and says, oh my God, like nobody's controlling this. Nobody's designing this for fairness. They're designing it for opportunity. Anyway, you have a role in that. I want to bring you in because I've got 16 seconds. What client data, this idea of how do we construct things ethically. And I think this is important for you. People argue it's way down the end of the show. I think you are. I'm going to call this the actuarial castle. Can I just challenge you to say that I think you might be hiding inside the actuarial castle? The space that you think protects you from responsibility because you are doing what happens in your silos. You are informing yourselves about products, you are analysing the significance of things, but overarchingly that generally bigger story about its relationship to other professions and other roles in the system is important. All professions are related. My culture tells me that. My academic life tells me that. Nothing is in isolation. It's a fiction. It's a complete fiction to say they're in isolation. Just a small, tiny example to close that out because I'm over time. I hadn't thought of this before David began talking, but just to show you the relationship between things. My father has asbestosis. My father is a victim of the James Hardie processes. He is dying from asbestosis. I don't blame David for that. I don't blame, that's comforting for you, I'm sure, David. But nonetheless, I'm mindful that he will not have the financial future or the life that he had, and he can't get access to it because that fund didn't exist in the right way. We've had to sue through the courts, we've had to proceed, take legal action and participate in those issues. Again, that's just part of the story of connectedness. I'm not making that a judgment, that's just we are connected, we are all human in this process. Can I tell another little small story about that? David mentioned the directors who have all suffered in that particular story. He also mentioned the press release that went out that indicated that this was a fully funded scheme. One of my very dear friends was that communications officer who committed suicide a year later after that particular issue. So I would argue that the directors may have suffered. He took his own life as a consequence of the weight of that particular concern. These are human things. This story here is a complete system where human beings are involved, where none of us in professional spaces can afford to live in the fiction of our silos when we have responsibilities across that entire system. So with that, I'm going to stop for a second.
Thank you very much. So I've got to say again, that's rather sobering in terms of the earlier video and what we've discussed now, that the consequences are very often much deeper and more painful than we thought they would be. Can I invite the rest of the panel to join us now? David and Deen can take a short break. We have coming up here Simone Braithwaite, who is the president of the Caribbean Actuarial Society and a consulting actuary with a variety of experiences both in and out of conventional actuarial work. The full CVs are on your iPad app somewhere, so I won't be going through them fully. Suee Chieh, who is a Singapore actuary, was past president of the Institute and Faculty of Actuaries, ex-CEO of a life insurance company and various other companies. Also, incidentally, a good friend of mine. We've been meeting on Zoom for a year or so, discussing philosophy and professional ethics. John Robinson, who is the president of the Society of Actuaries, and also a consulting actuary and with a long range of experience, and David at the end. So we represent, we're strong on the Americas. We've got a couple of Australians and Caribbean was the Americas.
No, I'd go with Caribbean. I'm ex-South African. John's just been visiting Ghana, so we've got a bit of an African connection. I'm afraid the only connection we have with Europe, Suee Chieh, is your membership of the Institute and Faculty of Actuaries. So you'll have to talk about Europe as well.
Okay. The problem is global.
Yeah. So good to have you all here, and thank you for spending time. So I'm going to ask them first as a question, just to talk about their experience of failure, of professional failure in one way or another. You might not want to talk too explicitly and might talk generally about a fabled country somewhere else rather than embarrass anyone. But please, certainly, Simone, perhaps you could start us off.
Oh, on the failures?
On failures.
Yeah.
Not your personal ones, because we know they're
Right.
few and far between.
Well, thankfully, I'm not building any physical bridges, but I've, built bridges into emerging risk areas and into new territories in the Caribbean. And I think in relation to some of the stories I've heard, I think some analogies would be it's always very important to get explicit peer reviews. A CC is not a peer review. Also, making sure you're speaking up and documenting issues to the right people. And even if you think these people should know what they're doing, and you represent a regulator or accounting standards, you should always be vocal and let it be known. And just generally in terms of emerging risk, you know, even if there's not a standard, explicit standard already in your country, there may be other, I mean, the standards themselves have principles that will generally be able to guide you in your work into different territories and risk. And maybe in other countries there will be actually standards already developed, like I say, in Australia has some principles and guidance on climate change, so you can look to other actuarial standards to help guide you, even if your own region doesn't have the standard as yet, or guidance.
Thank you. Suee Chieh?
Could I just ask the time? Is it the
No, I wouldn't
amount of
worry.
time left
Could you switch our timer off? That's
Okay.
distracting my panelists.
Okay. Because I could talk about failures in professionalism, very similar to the Royal Commission in Australia about opaqueness of product, expensiveness of products, and also the purchase and sale of agency forces in Asia, which truly would not serve public interest. Yeah? I could talk about that. But I thought it was really important what Deen introduced in terms of the culture and narrative in which we all operate. Yeah. So I think I would like to introduce some concepts here about levels, and the second one about lens, pluralism, of how we bring our own lens into this discussion. Firstly, I want to acknowledge David, whom I only know recent months, for his courage to own up to a mistake made 10, 15 years ago, which provided the space for Justin to be brave, because that is a very necessary part of our leadership, to speak up and create a space to change the culture. Yeah? But I think more interestingly is what Deen introduced, right? Because he talks about anchoring the conversation. And I could go down to a level and talk about commissions in Asia or the sale agency force, but I'm not sure how helpful that is, although that needs to be done by regulators to look at technical siloization to provide rules for people. But how do these rules came about? That is a story which began 60 years ago, and for some, 500 years ago when we became reductionists, and maybe for you,
65,000 years ago.
65,000 years ago. That's why we are here. But the world is an imperfect place, right? So we can't try to perfect it. But what can we do more systematically and systemically as professional bodies? Because that's what we are. We are just a professional body, and we can't change the world. How could we create a space for more courage, for more systemic thinking? There is a room, there is a role for providing rules. Yeah? I remembered when I started in Prudential Singapore, and the Monetary Authority of Singapore said that let's have freedom with disclosure. But with freedom with disclosure, instead of prescribing limits on commission, the commission actually went up, not down. So it's unintended consequences. And that was held in a narrative of market capitalism as ignited by Thatcher and Reagan in those times, where greed is good and greed. But the narrative has reversed in the last 15 years, with the financial crisis. But yet we still a lot of inconsistency. I think for me, I saw the clip on LinkedIn this morning about yesterday's customer trust presentation. It talks about leadership and governance. I think we can't change everything which is very high and systemic. Like Daniela Meadows says, you go higher up in a paradigm, basically you got to transcend the paradigm. I don't think as a profession we can do that. We just got too many multiple plurality. But what we could do is actually try to change the context, change the narrative of our conversation. And for that to happen, we got to start with ourselves, you see. We can't ask the IAA to do it or IFOA to do it. We've got to start with ourselves. How could we influence the conversation in our professional body and be bolder? Yeah? I think there's tremendous lack of courage in the profession. Yeah? And I tried to speak to that in my session yesterday. We just got to be bolder, and some of us who are bolder should push the frontiers more to create a space where things are clearly not acceptable, right? I retired full-time last year, and my banker wanted to sell me an insurance product, and he brought his bank assurance specialist from a leading insurance company in Singapore, sold by a leading bank in Singapore, a product which shouldn't be sold. It shouldn't be sold. And I want to get a copy of the quotation. They refused to give it to me unless I give a full financial analysis. But I know that it's pointless for me to go to Monetary Authority of Singapore because there will be somebody there looking at rules. Yeah, looking at rules. But a product, if I speak to the person outside MAS of Singapore, she will say that this product shouldn't be sold. So we are in this logjam, right? So somehow we got to loosen this, right? And I think it requires individual action. So this is the extent of my reflection at this point in time. But I really am thankful to Deen, who I met for the first time today.
Thank you, Suee, Chieh. John, what comes to mind for you?
Okay, well, I'll take a different perspective and perhaps a different track. And so I've got some observations in terms of what are the key sources of failure. And I want to thank my good friend Ken Kent for helping me out with that. He's here in the audience to keep me honest. And so just as a general thing, I can't say that I have necessarily experienced all of these things, but yielding inappropriately to time pressure from the client, and I think that was something that your message certainly brought to us. If the client wants to produce a certain result, giving into that pressure. Lack of, and I think, Simone, you mentioned it, lack of or insufficient peer review. I have a little firm with just one client. It's a 30-life pension plan. And I'm constantly concerned about making sure that what I'm doing is right. And so I need to have it peer reviewed by someone. And so if it's not sufficient or none at all, you can get yourself in big trouble. Too much faith in the model, I would suggest. If the model says so, then it must be true. That's not a good idea. And the last one I'll list is pressure from other professionals. Now, you're an attorney, and in U.S. law, everyone is entitled to a vigorous defense from an attorney. And whatever that attorney does to defend you, I guess within certain rules, is appropriate. There's also a concept in U.S. law, depending on the nature of the case, that all the attorney needs to do is to create reasonable doubt. That is not a quest for the truth, by definition. And so you can have conflicts where the actuary is more inclined to want a balanced view, but the attorney's objectives and inclinations are quite different. So those are the ones that I identified as perhaps the big problem areas for us.
Thank you. I'm going to try and put some questions together and sort of see how we go on that score. And it relates to your question about the actuarial castle, Deen. And you spoke about the professional regulation. Is that the right tool? So could you just expand a little bit about what you think the professional regulation should do, and particularly in the lines of the speaking out, being courageous, not yielding to the pressures that John has spoken about?
Where I've got to in my thinking about regulation is that regulation is always most effective when it is closest to the regulated, which I think is a ringing endorsement of what I just said from Suee. But But this, because in fact in most regulatory systems, in most statutory systems of regulation, it's designed by people who've got no idea whatsoever about the subject they are regulating, the market within which it sits, the context within which that market sits, picking up, some Suee's points. And so I do believe in professional regulation. It must be designed by those who are regulated. But the tension, obviously, is that those people who are operating in that space, the point being about the castle, aren't always aware of the consequence of the function that further exceeds that. So I believe deeply in the idea of professions being regulated within their system. You are designing beautiful standards and guides and debating them endlessly. And as the regulator of professions, I had no idea what you were doing. And in fact, I'm constantly told by actuarial friends of mine, some of them presented here, that nor should you. We do this ourselves, thanks. Don't tell anybody else. Well, then you are missing the connection to the rest of the system and the relationship between those systems. So the speaking out has to be about others as much as it does just about the profession. And I mean, I think John's quite correct about law. As an example, is that what we know about corporate failure in all of its forms is in every single failure of a corporate, there's at least a general counsel. There's at least an internal lawyer. There's usually at least an internal accountant, and probably somewhere in there I'm going to say an internal actuary, or at least somewhere in the systems. We know that in almost every single corporate failure. So, and I would argue that sometimes those three are not working together to understand their professional duties to the wider system. And if they did, we'd have stronger corporate systems.
Thank you. Simone, yeah.
Right, and I would add to that, in some regions, the regulations aren't enough. You're hired as an actuary for a compliance purpose. So you need to comply with this guideline and this regulation. But actually it's not adequate from a prudent, it may not be adequate from a prudency point of view. And it may be, you're not necessarily hired to give that, that voice. But I think it's important to speak up to it and to the right people, because if there is something does happen, they will say, oh, well, we had an actuary. So you have to be very careful about, yes, you were hired to specifically comply with that guideline. I know you've done that, but sometimes you might be aware that there are gaps in the regulations from a prudency point of view, and I think it's still our role to speak up on those and to the right people, because if you speak it in the wrong room, that's not enough, especially if you know it's not going to get heard by the right people.
Chieh?
Okay. Regulations still have to exist, right? Because we're going to turn up on Monday, companies still got to run, right? But think of the global financial crisis, think of auditors, think of rating agencies, think of lawyers, think of bankers, right? That system, they're all trying to beat the system essentially with regulations. I have a thought leadership group in the IFOA, outside the IFOA, called the Actuaries for Transformational Change. And we deal with these issues, and we invited John Chieh. John Chieh is a Financial Times journalist, and he wrote Great Estate with Paul Collier and Radical Uncertainty with Mervyn King, the previous governor of Bank of England. And we asked him what is the best risk management models. Right? He said, actually, the risk management models have to sit with the company because they are the only one who understand the risk. Any things outside the company invented by regulators, they'll try to beat and try to optimize. Yeah? So you got to make the risk management system within the company. But therefore, it has to be owned by the company long term. But as a context for that, there needs to be a rise in ethical leadership. Yeah? So we had ethical leadership, he and Paul Collier claim, in the 60s and 70s in the UK, where there was a narrative as a belief that lawyers are honorable people, accountants are honorable people, auditors are honorable people, doctors are honorable people. In my society where I grew up in Malaysia, it was like that. You want to certify a passport as a certified true copy, you go to these professionals because they were the icon of respect. But today they are not. Look at all the big four. Look at the auditors, look at the lawyers. And that has come from the technical reductionist training we are giving to actuaries, to lawyers. They are spending time to defend banks, CEOs, and board of directors from unethical actions. They are not seeing the big picture. So we need to get back to a space where we see the big picture. What is going on here? what's going on here is that we are protecting small little silos of our responsibility when the system is on fire. So we somehow got to relax from this technical siloization into a wider narrative, which is about the commons, time horizon, which is afflicting everything in what we do. Somehow there needs to be an unwinding. But at the meantime, AIA got to exist, the Regulatory Commission got to exist in the context of next week, next month, work still got to continue. You still got to hold that structure while change is taking place, not in regulations, but in our minds, to create the cascading effects of change. I spoke about Kairos yesterday because all of us are thinking in terms of chronos, right? What is the timeline for change? The timeline for change is in our head. If together we can create a tipping point for change, it will come. I'm optimistic if we continue to be engaged, continue to listen, continue to influence, that tipping point will come.
John, you?
Just discussing just regulation in general. My last job was as a life insurance regulator for the state of Minnesota. And for those of you who may not be aware of how the regulatory system works in the states, each state has its own regulator, and then they come together under an organization called the National Association of Insurance Commissioners. So there are two trends that one of them which I think is good, and particularly with respect to life insurance. We sell very complex products, and gradually the reserving for those products has been moving to a principle-based methodology as opposed to a rules-based methodology. But of course, there has to be a lot of trust in the system for that to work. But I say in terms of regulation, one of my biggest concerns is there are two areas. One of them is there is a certain product that we have called ULSG, Universal Life with Secondary Guarantees. And when the rules first came out and the reserves were calculated and so on, we found that the regulators found that the actuaries' reserves were too low. So then they produced another generation of rules. And again, the actuaries found the loopholes to make it too low. And this has gone on now probably around 6 cycles with just that one product. Eventually, they put it in the principle-based and said, you got to do it right. So that I think is a positive. But the other area that has to do, and you talk about products and marketplace, has to do with illustrations. Again, just an example of a product, we have something called an index-linked universal life. And there are some rules out there for, we try to put some rules and parameters around how to illustrate this thing reasonably. Of course, illustration is this big game because whichever company shows the highest values gets the business. So in some sense, it's high stakes to them. And so it's very interesting. The companies come rushing to the regulators and they rat on each other. That company is doing the wrong thing. You regulator, you got to fix this. So my boss, Fred Anderson, says, all right, we're going to fix this. And they put out a new set of rules trying to rein in some of the abuse. And sure enough, months later, you get more word about, abuse. So the one thing that I find I wish our profession would not do is constantly trying to find loopholes in regulations and just quit that game. I don't know what it will take to make that happen.
Can I just briefly respond to that point, because it's such an exciting or interesting line of dialogue about the fact that one of the strong contentions about regulation is, as I've mentioned already, it sits within a system. It's a systemic framework. And what I'll openly say that most regulators have no idea that they are in fact part of the system. They think they are regulating somebody else's system. So it's a bizarre concept. As I say, from an Indigenous perspective, everything is in the system. Nothing sits outside of the system. It's all in the system. But regulators and statutory frameworks insist somehow they are above it or objective or independent, which is my challenge to actuaries. There is no such thing as objective independent. There is a version of it that is quarantined for your expertise, but ultimately what you do has consequence. What regulators do shapes a market And I find that fascinating that we haven't found a way to respond to that. And we still, this fiction of law sitting outside the system. So I want to acknowledge the point you're making is that actually there's an old saying, a simple saying from fiction, from current zeitgeist television, that without, there would be no Joker if there was no Batman.
Yeah.
You know, we in fact create our own worst systems. That's the consequence of system.
Well, you raise an interesting point, and I'm not sure, you know, how the regulatory process works in other countries. But whenever there is something under discussion, two things I'd say. One, let's just take the actuarial realm and reserves and all of that. There's always going to be some technical experts, particularly provided by the American Academy of Actuaries, who will look at the situation and help the regulators to analyze that. And so it's not just the regulators alone sitting in some ivory tower trying to figure these things out. And the other thing is that in addition to the fact that we have technical experts, the employers and their representatives and their actuaries can get involved in the discussion as well. And so I like to think that in the end, the regulator is being assisted in making the decisions, and it's something that everybody is prepared to live with once we do make cast those final votes.
That's a good point.
Can we just keep on this tack or sort of broaden it slightly? So what struck me a couple of times, sort of the logjam that one spoke about, there's a sociological term, I think, called path dependence, that the institutional structure depends on what's happened previously. That's why that the institutions are quite different in different parts of the world. But clearly all institutions and regulations are not just, they might have appeared to be spontaneous, but they're actually the effects of people making an impact. Mm-hmm. And we can feel quite imprisoned by the regulations because we can't seem to make much headway against them. Mm-hmm. So the one question that came out here was, how can we, how does it work out? How can the actual profession bring actuaries to a point where it's normal to speak out? Normal to speak out. And if you've got some thoughts about that, and I think particularly about the problem one faces as a whistleblower. I mean, that was the pressure that you had, David.
Yeah.
And I think that's all, those of us who've spoken out from time to time feel vulnerable about whistleblowing. So is there something the profession can do, or is there a way of making people more resilient?
Let me try to come up with a positive statement. My dear wife was for many years a counsellor, and Judith's technique for almost every question that she would ask would be around the word "I'm curious about," ... which enabled her to have conversations with people and to raise questions in a non-threatening way. Whether that's us, as board members, Trevor, and raising things in that context, whether it's talking with other professionals, I wonder whether we need to be, just more curious. And it's interesting. I think Tony Coleman made exactly that comment as he was talking earlier about the work that he's done recently. In the costing how much climate change would have been exacerbated by the creation of a particular coal mine. So I wonder whether, in fact, looking positively like that is a way forward. I guess my particular interest, as a number of you are aware, in codes of conduct. When the Australian Institute did its last review of its code of conduct, we moved from a rules-based system, which is around about a 10-page document or something like that. It had grown from the original 4 pages, which Alf Pollard and others wrote back in 1975. And I think we got to the stage as we were reviewing it, was to say we can't have this thing continue to grow. As we asked around the profession, what do you know about the code of conduct? I would ask senior colleagues, about the code, and they quoted things to me from 2 or 3 versions ago, which were either no longer in the code or stuff which was still there. So I think that it's really important to find very, very simple ways of addressing these things. Principles-based code, I hope, is one way that we do that for the profession. But then, of course, we're looking beyond that as well, aren't we? How do we work with the other professionals and the business people and the regulators and the governments that we want to help in order to be helping society. And I think we need to be asking those questions about, I'm curious about that. Where will that take us?
Simone?
I think in some cases in the history it's been personality driven. We have some actuaries who are like philosophers, and I remember working with Alan Brender, and he would always come up and question the system, and he's very comfortable doing that and challenging the way we do the valuation and whether the regulations were adequate. But that question's made me think maybe there is a way that we can form like an anonymous box where we can put a comment in. This doesn't make sense under IFRS 17 or capital standards are inadequate, and we don't have to put a name on there. It's out of the box, but it's possibly a way to get some of these questions out there and answered by the system makers.
With surveillance these days, no one's safe. But a good idea, yes. Suee, Chieh?
Okay, I want to follow with David's very practical idea, because we've got to be practical as well, right? He talks about moving the envelope and whistleblowing and encouraging more Justins to speak up, right? So I look at the Australian Actuaries Code, I look at the US Actuaries Code, and also the UK's Actuaries Code, because I have a live case in Singapore 12 months ago. And I want to look at the speaking up. The speaking up provisions in Australia is the widest, yeah? And it catches the responsibility, compel the actuaries to think of wider issues. I think it's the most, although UK came before you, yours is, was the widest, I felt. Because there was a case in Singapore where we needed the actuaries to think wider than the narrow task they were asked to do. So everyone stuck to the narrow task because that's what the client wants the actuary to do. But I believe that person would be caught under Australian code, because but would not be caught in the US code at all. Yeah, UK is arguable because US code was very rule-based, and in fact there was no speaking up provisions. Yeah, it's about technical. You do what you're supposed to do, right? But what is right or wrong is another set of issues. Yeah, another set of issues. But I like the Australian code. But Australian code cannot be too aggressive either, because it will carry along a whole group of people with diverse points of view. That's where pluralism comes in. But those who are at the boundaries of change will have to continue to push the edge. Yeah, because if you are in the middle, you're taking up too much space, right? You should be at the boundary and push the edge. You believe in the philosophy of speaking up, about courage, about challenging opinions which are held as orthodox, or by people who are senior, who are doing the wrong thing, right? So those of us who have more leeway, the retired people, maybe, the people who, by personality, are more prepared to speak up, and create the space for change. I think that's the only practical way for us to change, because we cannot. You can go into politics, but politics itself is a problem as well, right? Yeah, so this is where we are. So I encourage the more David Mintys, more Justins to speak up when they see things not right. And we will disagree about what is the right answer. But clearly what we have today of being too narrow and sticking to the rules is not working.
No. Deen? Oh, sorry, Simone.
You can make David's speech mandatory for all actuaries to listen to. It's quite sobering, I think. So.
I want to acknowledge that I still and have dedicated my life. In fact, I'm officially Australia's chief professionalist. It's one of the jobs that I officially have. I do love professions. I think professions have an important and vital role in society. But the reason I love them is that I think that they are, in fact, about how we make commitments to each other to govern our own conduct. And to Suee's point, it's really important to sort of understand that that is a commitment that isn't rules-based. And so if I think about the cultural story of 50 years of legal structures around these regulatory models, but hundreds of years of guild-based professional systems versus 65,000 years of sort of governance and arrangements and relationships. If I bring it into, I'm challenged by David's simplicity argument. I think it's a good one. So I will share with you that in Indigenous culture, in Australian Indigenous culture, my culture, one of my culture, there are essentially only two sins. By contrast to the Christian traditions, there are only two sins. But those sins are ego and greed. Mm-hmm. Every single story that you've ever heard, that you've ever read or listened to from a Dreamtime story is a language that's used sometimes to explain our stories. That's a very simplistic word, by the way. It doesn't explain anything about the complexity of those stories, but nonetheless, that's our relationship with the West. It is about ego and greed. And if you think about the idea, even Simone's point about how we are frightened to speak up or challenged by speaking up, that is a statement of ego. It's a question of when you understand that you are no more important than the trees, than the kangaroo, than the emu, than the water. Literally, that is built into the DNA of my responsibilities in culture. Then what ego is there? There is no need for that ego. And if you can find a way, so that the challenges of why we might be frightened to speak into the space is an exercise in de-egoing. We are simply not important. That's a fundamental principle of culture. So if the two, and all, I would argue all the Christian traditional sins that emerged only a couple of thousand years ago are extensions of ego and greed.
Absolutely.
And professions are about that. I think professions are about how do we build rules and systems. And I say this, by the way, as somebody who's written quite a lot of the law in this country around this, that I've gotten, as I've aged, I've become less enamoured of the rules-based systems which give rise to rule transacting in legal systems and create loopholes and challenges and constant conflict. It's ultimately about ego and greed.
And at the end of the day, Christ said, love God, and love your neighbour as yourself. On these two commandments hang all the detail of the 10 commandments and the 613 other ones that are in the OT. So again, it's simplifying. Now, obviously, you say love God and love your neighbour. What does that mean? As he was then asked. But at the same time, we need simple things that we can keep in front of mind because we are human beings. And to that extent, while we can have piles and piles of regulations, I'm quite sure, Dean, there are very few lawyers who can quote you back the corporations law or even a chapter of the corporations law, let alone actually then apply it. So in order to be able to work practically, we have to come up with simple, memorable things to be able to operate by.
I'll just say, Tony, in our code of conduct, there is a precept that requires us to speak up, and that would be precept 13. And if I see Simone do something wrong, I'm required to report it. There are two components to it. One is I may approach Simone and say, hey, let's talk about this. That, I believe, is optional, but I am required to report it. So the code at least tries to do its best to get us to speak up.
Most codes, I took a look at the Australian, Caribbean, Canadian, and most of them have those similar principles about competence, speaking up, knowledge of the regulations and laws. We do have a lot of foreigners working in the Caribbean, so I want to emphasize, taking the time to be aware of the markets that you're working in. But I'll talk to you offline about the bucketing into greed and ego. That's interesting.
We've got a lot of law to describe greed and ego.
Yeah. So can I just follow that up? I mean, there's a theological debate about whether pride or greed is the root of all sin, and which comes to the same conclusion. There's a question from Chris Dolman. There's been an underlying criticism of rules and regulations in the discussion. And I mean, if you look at the 10 Commandments, for instance, the commandment against greed, do not covet. How else might we avoid tragedies of the commons and these other collective action problems in competitive market systems? How do we bring the best out of people in a sense? So we've argued the question of we've discussed how we might bring out courage for people to speak up. But are there other ways to bring out the best of people and make, as I think, Rick Shaw was saying earlier, that ethics shouldn't be a question of merely restraints, but an objective that we want a flourishing society, and how do we promote that?
I'll jump in first just to say very briefly that it's true that most law and/or rules and regulations are written in a way to affect or constrain particular behaviour. That is the nature of why we create rules. We see something bad that we want to stop from occurring again. That's the basis upon rules. So if you begin with that point, and it goes a little bit to Suee Chieh's point, that if you begin with that framework that we are here to stop bad behaviour, then that's the whole framework you have. When in fact, what you are asking, and I think quite rightly asking, is how do we encourage good behaviour? How do we write rules that are about encouraging good outcome? And that's why I think professional regulation is important. The regulation of professions should be focused not just on constraining bad behaviour, but on encouraging good behaviour. How do we reward it? How do we incentivise it? How do we value it? How do we see it, even, frankly? Because so many of us are just, the good work you do just goes unnoticed. It's only the bad work that gets noticed. But I think that's an important flip in the conversation, that rules are about constraining bad behaviour. Professionalism should be a way of encouraging good behaviour.
And I imagine it's, certainly culture is a very important part of that. How do you drive each of your organisations? I hope it's with some sort of value statement that says, these are the things we value in people. Well, that's great. But then, of course, you've actually got to put that into practice in the way that you remunerate people and the way in which you provide them with the resources they need in order to do that.
I've got two questions from young actuaries that I'd like to just put to you. So the one is, how do young actuaries get started on their path for ethical leadership when working in these existing legacy systems? What actionable advice would you say? And the other question is from Martu Ranjan, as a member of council, but is young enough, Martu. Failures can arise from putting aside integrity in the face of influential political forces and direction, or even threats to your job. Is it ever acceptable to act without honesty? And the challenge is so the challenge, I think, is what advice would you give to young actuaries who find that they do not agree with what's going on in their organisation? What do they do?
I imagine the first thing is to try and find a trusted person that you can share those concerns with and bounce them off. That will probably be, in some cases, a more senior actuary. Or it may be, a member of the family. It may be your minister, someone external to you, because obviously these things are things you can't do on your own. It becomes very difficult when you're the sole point of pressure in a situation. And I know that means that you're then balancing that against confidentiality issues around, client confidentiality and things like that. But hopefully, if you're finding a person who is, in fact, who's been through some of this stuff before and is potentially a mentor, that you can talk to them that way without revealing those sorts of things. But don't try and do it on your own. At the end of the day, as I say, I can take responsibility for these things now, but I've also been supported throughout that by a very wide range of people, both within and outside the profession. If I hadn't had that, A, my faith, and B, that support, I hate to think where I would be now.
This may be a little extreme, but it may be helpful if you're prepared to walk away. Mm-hmm. And I've had that happen. It wasn't an employed situation, it was a client situation. And I was setting assumptions for these valuations, and the chief financial officer of the school district felt like, she wanted to have it her way. And I said, no, this is how I do it. This is what, I'm advised to do, and I'm following the guidance. And she said, well, I'm going to change actuaries. And I said, well, if there's any way I can help you, let me know. Now, I had 130 clients, and I couldn't do that 130 times. But you may just have to lay down the rules as to how you're going to do your things. I found it interesting as part of the process of switching to that particular field. It's called OPEB, or the post-employment benefits. I had to find me a mentor, and this mentor was a gentleman who worked for another firm, and I later heard that she, the lady from that school district, approached the mentor. Now, I had told him the story, of course, and he turned her down. So I felt pretty emboldened by the fact that even he turned her down. So sometimes you may just have to walk away.
That's a good story.
Or walk away from a potential promotion, You have to be able to speak to power, because otherwise, you have to live with yourself as well.
Yep.
Mm-hmm.
Quickly?
No, I think it's Suee.
I thought it was a good answer. Walk away as well as seeing a mentor. That would be my classic answer. But I would ask myself, when I was 25 years old, 35 years old, designing products which I don't think was sort of right, whether I would walk away or would I would challenge my boss all the way to London, right? These were the days of front-end commissions. These were the days of very competitive illustrations against my competitors. These were the days of, for those who can remember, capital units, which is clearly an invention of actuaries. So I doubt I would be able to have that strength, even I like to think I have a strength. But I would welcome, given that this inflection point we are in, we should have a profession, a community where it's clearer about our purpose, right? About our purpose and the narrative, right? About promoting a society which is sustainable and encouraging fearlessness more explicitly. That would help me, I think, if we can start beginning to articulate that language of purpose, right? Because our purpose are still very much based on career and skill sets, not on values. Yeah? I think the shift to values and purpose, the timing seems to be emerging, I sense. It's no longer just skill sets and data science. It's about how do we create a better society. And if our profession, which is a profession of long-term risk professionals, believing a sustainable system could lead, or in some way help to lead, I think it would be a wonderful thing.
That's a great intersection with where I was going to go, because I think all of those things are true. You can put in place processes and mechanisms. You can create anonymous lines. I've done all of those things in different roles over time to create those sorts of spaces for speaking up. But I've got to say the only tool I've actually found that does generate more engagement with it is to simply be truthful with that whistleblower or that person who wants to speak up. And I don't think we are truthful enough. Their career, unless they walk away, is likely to be over. That is a truth. We see that time and time again in whistleblowing. I'm not saying you shouldn't do it, in fact, but that is the point. I have walked away from a number of jobs, including this job that's relevant to this particular role, because I disagreed with the policy framework that I was required to implement in that framework. That was a government-mandated system. I couldn't do it and meet my ethical obligations, so I walked away from that particular position. The industry still rings me up with hate mail and on frequent occasion. But I was privileged. I was able to do that. I could move from there to be a partner at Deloitte. Right. Like, you know, hardly a position of lacking privilege. I do agree that as a 17-year-old I would have had different questions. And I think we need to be truthful with people, that we need to create spaces in professions that are spaces of truth. Because it's only when you get to have that truthful conversation about the cost and consequence, but also the significance, the importance of that we have to create those spaces for them. I think that is a job for you in the profession, to create that space that says this is the space within which things can be safe, within which we can have proud, brave, challenging conversations, and you are protected in this space. When you do it, give me a shout, or I'm happy to build it with you. That's what. No, I'm at Deloitte. That's right. I'm at Deloitte. I'm supposed to ask you to. I'm supposed to ask for some sort of project. That's right.
Yeah, and just to add to that, if you can do it in a way without pointing fingers or blaming people, that might actually be a more constructive way to do it. That wouldn't harm your career.
Yeah, but that's sometimes a good luck. Well, we don't quite have enough time for another question, seeing it says 28 seconds. I just add my little bit to that last question, is that as a white South African in South Africa during apartheid, a lot of us, there was pressure to emigrate because one wanted to leave, to get out. But interestingly enough, I was stuck in hopefully making contributions to change. And when we left, my sons told me that my major moral failure was in fact to leave. So it does, I mean, there's a situation where we can't leave. The world is crooked in many, many ways. We can't always walk away, and sometimes it's right to stand and fight. But one somehow has got to maintain one's integrity in that business. You certainly do not want to self-immolate as a young person. Don't put yourself on fire. And ruining your career is not going to make you more effective later on.
Or impact.
So speak to senior actuaries, speak to wise people, and don't explode. Although it may feel like the right thing to do. I think we could talk I could listen to you guys all day, and there's lots more to say. Hormo's actually suggested that we should have a regular workshop on this basis. She asked the question, but I think that's a good idea, that maybe the profession should be looking at regular workshops on ethical questions and how to encourage people to speak up and
giving stories like
and
that.
give stories, yes, because that story is really a very powerful one. So please join me in thanking the panel. They've done a wonderful job.